Hello there, good evening and welcome to Political Links on Voice of People VOPT Television. We are broadcasting on Metro SLTV channel 202. I am Chukwuma Okore, and today in the next 1 hour, I'm going to have a one-on-one with Professor Chidi Odinkalu. You know, Professor Chidi Anselm Odinkalu is a Nigerian human rights activist, he's a lawyer, professor and writer. He was the former chairman of Nigeria's National Human Rights Commission, NHRC, and was recently the senior team manager for the Africa Program of Open Society Justice Initiative. He has worked as an advisor for the Ford Foundation in New York, World Bank, African Union, International Council for Human Rights Policy in Geneva. In 2018, he co-authored a book titled Too Good to Die with Aisha Osori, and in August 2021, the Fletcher School of Law and Diplomacy at Tufts University appointed him a professor in human rights law, and he currently serves as a visiting professor to the Fletcher School of Law and also Harvard University. Good evening, Professor Chidi Odinkalu, and welcome to Political Lens. Good to have you on my show.
Thank you for having me. Good day, sir.
All right then, Prof. Thank you very much. Let's start with your work you did. Human rights as the chairman of the National Human Rights Commission, and you know, I want to start landmark successes in human rights community which can be attributed to your tenure in the NHRC. What was it like? What was it like? Just a general overview of what you did as the chairman of NHRC. Were you able to secure some form of space in the human rights community for the Nigerian people?
I don't know how to put that. Was I able to secure some space? I mean, it's difficult for me to tell my own story, I guess. So that's the challenge with this kind of question, or at least leading off with it.
Okay. Go ahead, Prof. Go ahead.
I started off at the National Human Rights Commission as in a transition. You know, the National Human Rights Commission, to start with, was set up in 1995 under the Abacha regime. At the time, very much as an institution, as an entity, largely to help the regime launder its image in a very difficult time. It was in the aftermath of the execution of Ken Saro-Wiwa and the Ogoni advocates. And for much of the period until 2010, 2011, the commission existed essentially as a department in the office of the Attorney General of the Federation at the Federal Ministry of Justice, for the most part, although it had a different building for its operations. In 2010, the law was amended to make the commission slightly more independent. And I came in that transition to help the commission work its way to discovering how to be an independent institution. And I can give you two illustrations amongst many other things. Although the commission had been in existence for essentially 17 years before I came in, it had no rules of procedure. It could deal with petitions and communications and complaints, but it had no procedures for doing that. And when they brought me the first set of petitions and asked, under what rules have you people handled these, people didn't know what I was talking about. So I instituted a set of rules for managing the Human Rights Commission. And those are the rules that they're operating with still today. If you ask me what my biggest achievement is, I'll tell you it is the rules of procedure of the National Human Rights Commission. It's called STOP, Standing Orders and Rules of Procedure of the National Human Rights Commission, because you've got to handle things properly. You just can't be making things up as you go along. All right? So that's the first thing. The second thing is that when I got into the National Human Rights Commission, the commission was doing about 30,000 petitions per annum. About 30,000 complaints it received from different sets of Nigerians, and you'd say that's quite substantial. By the time I left in the middle of December 2015, at the end of my tenure, because the tenure of the chairperson is 4 years,
okay,
the commission was doing over 2 million petitions per annum. All right? Whoa. that should give you a sense. So if you ask me what it was, I think people took notice that there was a National Human Rights Commission. They had some capabilities.
Okay.
And therefore, the scale of its public regard did change.
Okay. All right, Prof. You have just simplified a question that you termed was difficult in the first instance. You have simplified it, and it's easy for someone to understand now how you were able to put the NHRC, in spotlight, in limelight within the Nigerian Human Rights Commission. Now, that said, the NHRC is essentially an agency of government, which serves as an extrajudicial mechanism, for the respect and enjoyment of human rights. It also provides avenue for public enlightenment, research, and dialogue in order to raise awareness on human rights issues. Now, because it's a government agency, and I recall that at one time, you were the director of project and planning for the Civil Liberties Organization, CLO. So essentially, you were an activist. Now, activism runs contrary to, not that it runs contrary to, it's more like they are always in opposite direction with the government, because essentially when you talk about human rights, the main culprits are the government and its agencies in terms of police brutalization, military infraction on civil space, and all of that. So essentially, you were an activist on one hand, clearly protecting the Nigerian people as an activist, as a non-state actor in that regard. Now, how were you able to transit from being an activist whose calling is to protect the citizens from abuses, mostly committed, by agents of government and its agencies? So how were you able to transit and work for the same government that you were almost against? Was there some kind of backlash from the civil society, human rights community that said, oh, why is Chidi transiting from this side to the other side? How were you able to create a balance during and after service?
Well, I don't know. I don't know. First of all, every one of us is multidimensional.
Okay.
Okay. Activism is not what pays my bills. It doesn't put food on my table. It's a vocation that the fact that I get to engage with people who are in difficulties, and I'm able to sometimes play a role in finding out whether it's possible for them to get remedies or assistance, is a choice. At the risk of considerable immodesty, I graduated at the top of my class at every level: primary school, secondary school, university, law school, with multiple prizes to show for it. So I could have made other choices. I also have a PhD in law, and my research interest in law is international economic law. It's not activism. So there are lots of other things I do besides activism. That's the first thing. Now, it is true that sometimes an activist can articulate a case that in which the government is on the other side. But I want to just make a few clarifications.
Okay.
And the calling of an activist basically is to be true to the facts and true to people and true to the remedies and law and evidence. And those things really don't take sides as such. The fact is that in our country, many people get left behind by circumstances. And many people are unable to therefore get the remedies that they deserve. And it's important to address the needs of those people. I should also clarify that the Human Rights Commission is not an agency of government. It's an agency of the Nigerian state. Government is an entity within the Nigerian state. It's not the only entity within the Nigerian state. And the Nigerian state embodies the intersection of government and civil society. The Human Rights Commission, amongst other actors, the Human Rights Commission is there to mediate that relationship between those sides. And that's really how I saw my role.
Okay.
The third thing is, I think it's important for those who go into public service, and I didn't go into government, I did public service. Those who go into public service have got to understand that you're not going to be there always. And therefore, you need to live a life that you can sustain when you've left office. By the way, the position of the chair of the National Human Rights Commission is not remunerated. They were not paying my bills as chair of the National Human Rights Commission. It's not a salaried position, okay? I chair the governing council. I provided strategic leadership. I provided moral authority for the work the commission did. And therefore, I'm sure that there were people who probably had challenges with that. But I was quite clear that I was also not going to be doing that for the rest of my life, or being in the state sector for the rest of my life. And therefore, it was important to retain my credibility and authority for when I came out. And the test of the pudding is in the eating. I don't think that there have been more vocal or more articulate voices in the non-governmental sector than mine in this period since I left the National Human Rights Commission. If there is anyone, please tell me.
Okay, very well said, Prof. I like the fact that you said something quite instructive, that, look, some people were not comfortable. That is the backlash I talked about, people from your community. Now, before we move on to other things, when you say that that the NHRC is clearly not a government agency, but owned by the Nigerian people, run by the Nigerian state, at whose instance were you appointed as the chair of the NHRC? Was it the people that appointed you or the government that appointed you?
I was nominated by the president.
Okay.
And I had to go through confirmation by the National Assembly, by the Senate.
Okay.
So I was nominated by the president. I went through, first of all, I went through vetting with the police and then with the State Security Service. And then after that, you've got to declare your assets with the Code of Conduct Bureau. At the point, I was the only person at that level whose assets were public, because for me it was important to make sure that people understood I wasn't coming to this with money, and I was happy to live with what I came in with. I didn't want people coming to me and saying, "Oh, as you have become a big man now, please give us this one," because I'll show you my asset declaration form and ask you which one do you want to take. Okay. All right. Yes. So for me, it was that easy. And when I see people hiding their assets, I don't understand what they're hiding them for. None of us is going to leave this place with your assets if you have any. And if you don't have any, it's okay too. But what is not acceptable is to live a life that you cannot afford, or pretend that you are whom you are not. So I didn't want to do that. I wanted to be able to say, this is who I am, this is what I have. And when it's all done, I go with what I came in with. That's exactly what happened. I didn't go into the National Human Rights Commission with anybody's car. I didn't live with anybody's car. I did not accept official car as chair of the National Human Rights Commission, because you see, when you accept official car, you get official driver. Whatever you say inside the car, the driver will report to somebody. If they give you security guards, the security guards are reporting to people. I wanted to avoid all of that. I lived my life, and when it was over, I left as I came in with nobody watching what I was doing.
Okay, Prof, I must admit that you've done well for yourself. At least you've been able to acquit yourself, honorably. Now, it's good that you made the clarification that you were nominated by the president, and you were cleared by the police, by the security agencies, and finally screened by the National Assembly. So all of these three people, agencies of government, because I was trying to situate the fact that NHRC is not an agency of the government, but of the Nigerian state. Well, that said, let's move on to other things. Now, how will you assess the human rights record of, I want us to bring it forward now, the human rights record of this administration. We have seen cases where activists and journalists are hounded. David Hundeyi is on the run. Fisayo Shoyombo has been in and out of detention. Omole Showore, it's always been in and out. They seized his passport, released it, arrested him, invited him, and all of that. People have not been allowed to freely criticize this government. There's a Cybercrime Act. Minors were jailed in the aftermath of the End Bad Governance protests and charged with treason and more. How much free are Nigerians, How much freedom do Nigerians have to speak up and hold this government to account? And I would like for you to juxtapose it with when you served with the previous government. What records do we have now? Is it something that we should be happy about? Is it something that we should share about? I want to have your broad reaction to the free space in Nigeria.
Well, any record on human rights, to the extent that it exists in the current dispensation, in my view, is quite abysmal. If you remember, the Bring Back Our Girls movement used to have its sit-ins at a park in Abuja. That it was the Buhari administration that sealed off that park and exiled them, having used the Bring Back Our Girls movement to having instrumentalized the movement on its way to power. Look, the broad issue here is a government that has legitimacy deficits will not want to have a vocal citizenry, because that will always remind it of its legitimacy deficits, unfortunately. And so in the way that the current administration came to power, it was always certain that there would be problems with free expression, the right of participation, political assembly, and related issues. And it has been set up in that way with what is happening in the police and the procurement of, in my view, unlawful extension to the tenure of the Inspector General of Police, which really means that the Inspector General, which has always been a difficult position for anyone at the best of times, can no longer claim to have any modicum of authority or independence in taking operational decisions. They've always got to take dictation from the presidency, because once you overstay your time and you get this kind of dispensation, you are really at the beck and call of the administration or of the president. That's what it is. And so the underlying architecture or layout of the administration and its most strategic institutions means that it's not possible to get the kind of thing you're thinking about. But it's a little worse than that, because the institutions that are supposed to provide remedies or help citizens have hope that they'll have remedies, even if there were abuses, have all been captured or destroyed in their capacities to do precisely what they are established to do, whether it is the independent institutions of the quasi-administrative kind like we've been discussing, or the judiciary, which is in a total mess, in my view. And so however you look at the situation, at the level of violations, at the level of institutional access to procedures for remedies, it's quite poor and indeed quite bad.
Okay, I've raised a lot of talking points now. Let me start with the instrumentalization of the Chibok girls, as a plan to power. Are you saying that some elements within the Nigerian society were behind the Chibok girls' capture and all of that? When you talk about as an instrumentalization of the process through which a certain set of people came into government, could you expatiate on that for the average viewer to clearly understand what you mean? You also talked about the legitimacy of this present administration, how they came into government. I mean, we had an election, INEC declared results, people went to tribunal, people went to Supreme Court. Supreme Court said, look, there was nothing with the elections and declared somebody a winner. What issues of legitimacy do surround, the present administration? And you talked about state capture too. You said a lot quite in a moment. So let's try to unravel all of that so that the viewer will understand. Let's start with the issue of instrumentalization of the Chibok girls. They are kidnapped and all of that.
No, but come on, a lot of the people involved in the, who participated in the unraveling of the narrative of what transpired or didn't transpire in the Chibok girls incident are still alive. As a matter of fact, there was a presidential panel headed by General Sabo that investigated it. It submitted a report, and you can access the report and make of it what you will. Are there issues that arise from the official report? Of course, there are issues that arise from the official report that raise legitimate issues as to what people knew, how they knew them, whether there was in fact instrumentalization at the level from the from the capture of the girls down to the political amplification that then followed. And it's amazing today listening to Nasir El-Rufai running from pillar to post, posturing as some kind of latter-day Democrat. But he's one of the actors who try to make political mileage out of the Chibok girls situation. So, as I said, the records are out there, and it's not difficult to figure out what may have transpired or what different actors did. Now, and that's the wonderful thing about the Nigerian situation. Sooner or later, you're dealing with fact scenarios in respect of which there are official records on pretty much everything. Whether you're talking about Boko Haram, and if you look at Boko Haram, we had investigations, official investigations, beginning with Marshal Dike's investigation in 2009, through to Gajigal Timari's panel in 2011, which actually identified a set of politicians as having involved or been complicit in the origins of Boko Haram and recommended them for prosecution. Many of those politicians are still alive, and a good number of them are in senior leadership roles in the ruling party today. Okay? Nobody undertook, in addition to what I just said, there was a government white paper on the Gajigal Timari report on the Boko Haram origins and operations of 2011. That government white paper committee was chaired by Prof. Ignatius Ayua, who at that point was a senior advocate of Nigeria and the Solicitor General of the Federation, having previously, before that, been the Director General of the Nigerian Institute of Advanced Legal Studies. Now, all of that is in the public domain. In 2013, of course, there was also another panel, by the way, chaired by the Minister for Special Duties, Tanimu Turaki, Senior Advocate of Nigeria. Again, that report is in the public domain. So what I'm saying here is not rocket science. It's not fiction. You can access all of these documents. I know the documents are classified. Have I read them? I have read them. Do I have copies? I do have copies. And so I'm not making this up. Okay. Now, in terms of what I said about elections, I'm being fairly straightforward when I talk about legitimacy deficits, because that's exactly what happened. And people always cite, oh, the court decided this and that. The courts are not where you procure legitimacy for regimes or administrations. Courts police the rules. If you are having to rely on judicial decisions to say that you have won an election, that tells you all you need to know, that there is a legitimacy deficit, and it's institutionalized and it's institutional. The one election in which you can say there was no legitimacy deficit was in 2015, when President Jonathan said, I am not going to court. The results were fair, free, and fair. The election was free and fair. I lost fair and square. Okay? But if you're talking about 2023, of course, there is massive legitimacy deficit, and the administration itself is very much aware of the fact. Now, that, to be fair, that's not the only election in respect of which there's been a legitimacy deficit in Nigeria. In 2007, there was one. The only thing is that the response of President Yar'Adua was different. He acknowledged that there was a legitimacy deficit, and he went further to say we had to try and redress that. And so he set up the Uwais Presidential Panel on Electoral Reform to try and address it. Of course, he died before he could have the opportunity to redress or address the proposals of the Uwais panel. But it's just to say that the idea of a legitimacy deficit is self-evident. I don't think the administration itself contests the point that it does suffer legitimacy deficits.
Okay, Prof. I like the fact that we are at this point now. Now, last week there was a U.S. court, which issued an order, to FBI to release documents that the Gloma Act, the Gloma law had clearly said, no, you cannot do that, or you can do that, or you cannot do that. And they chose not to do that. Now, last week, the court said, look, FBI, you can release these documents to the public. Now, why I'm asking this question is in the light of the fact that you talked about redress. Do you think that ahead of 2027, that the release of those documents can help Nigerians, seek a redress in terms of papers that were filed in 2022, documents that were submitted to INEC, which were clearly, questionable, which had question marks. But because the Supreme Court at a point said, look, we cannot, at a point, Atiku Abubakar went to the US, also procured evidence, but the Supreme Court said, look, we clearly cannot admit them. They had the prerogative by their rules, 70 subsection 2 of the Supreme Court rules, if I'm correct. They said, look, we are at the discretion, to admit or not admit, and they didn't admit. And at the end of the day, the Supreme Court said, look, this gentleman won the election. So my question is, do you think that the release of these documents could anywhere help the Nigerian people redress the issue of legitimacy that surrounds this government by saying, look, this person is not fit for purpose, or we can't go in this direction? Is there a possibility those documents could help the Nigerian people?
I don't know. I'm skeptical about that, to be perfectly honest with you. First of all, the tenor of the decision itself doesn't necessarily say whether or not there are documents. It says if there are documents, release them. So first of all, you've got to find the documents, okay? If you read the decision as well, it's directed at, I believe, FBI, DEA, but critically, it also says, the judgment also says the CIA did not have any documents there, which is important because the entity that runs foreign agents and foreign intelligence in the United States is the CIA. Okay. The FBI is a domestic law enforcement entity for interstate crimes. So the remit of the FBI is rather limited, naturally. So in the institutional construction of the entities that are implicated, it is well possible that there may not be anything, unless, of course, you're dealing with interstate crime. It is possible that there will be material, of course, but you wait to see what the material could be.
Okay.
Now, but even if you had that material, the material can only be used and useful if you have political parties that have the nous to use them. At the moment, Nigeria does not even have opposition parties. You talked about Atiku. What is his party? Peter Obi, what is his party? What is the state of the parties? The most effective opposition in the current dispensation in Nigeria has not been any of the political parties. It's ordinary citizens trying to do what they can. That's the problem we've got here. That at the moment, quite honestly, the so-called political opposition, to the extent that it exists, has been an absolute failure. They've been disgracefully out to lunch. Opposing the APC government of President Tinubu is the easiest thing to do. But the best that we have had are occasional tweets from Peter Obi and Atiku, and very little else. And they're disappointing. The only thing, in my view, worse than the APC government is the opposition. They've been dreadful.
Okay. Now, Prof, we are coasting home because we have about 20 minutes left, and we still have a lot of ground to cover. Now, when you talked about CIA probably not having much, I was thinking that this issue, the issue in contention, was within the borders of the United States of America, which clearly is under the purview of the Federal Bureau of Investigation. And if you recall, there was a certain forfeiture of $446,000, which were proceeds of crime, related to drug dealings. And the people concerned have not clearly denied. They even told Nigerians, look, there was a forfeiture. Now, I got into an argument with a group of friends the other day, and one of them said that, look, forfeiture, it's more like plea bargaining, which is an admission of guilt. So if we have all of that, I would like for you to briefly let us understand the essence of forfeiture within the legal parameters. Does forfeiture amount to an admission of guilt? And how would that impact the information, if any, that the FBI has, and its validity in the pursuit of that redressing the legitimacy issue that we are looking at?
Look, this took place in the U.S. legal system, and not in Nigeria. Okay. Now, can you have a forfeiture as part of a plea deal? Yes, you can. Okay. In the United States also, there is what they call nolo contendere, which is no contest. A nolo contendere can mean a disposition without an admission of guilt, technically, just as the technical process goes. Now, but the thing is, without reviewing the documents I will not be able to say what it is. Now, in any case, to the extent that there were orders made in that respect, those are judicial orders. And so they should be accessible ordinarily through the court systems as part of the court record in their specific cases to find out what nature the forfeiture took. I don't think you necessarily need to get that from any law enforcement agents because it was a judicially ordered forfeiture. It should be possible to understand the nature of the forfeiture from the judicial records.
Okay.
Yes.
All right, Prof. Let's move on. Now, you have been a very prominent member of the civil society group, and an activist in pursuit of human rights, having worked with the CLO, like I pointed out the other time, as Director of Projects and Planning. What impact are the current civil society groups making compared with what we had in the past, especially during the military era? The civil society groups, are they dead? More like, because they seem to have been more vibrant during the military governments when we had the likes of Ganifa Wemi, Olisa Bakoba, Ayo Obe, yourself, Yinka Odumakin, Clement Wankwo, Chimobane, Beko Ransom Kuti, and a lot more other people. Now, we don't seem to have such bold faces now. What's responsible for the short supply of activists? Is it that your generation didn't train successors, or that this group just, slid into complacency? I think the only active group now is SERAP. What happened? And the only thing they do is go to court. We have Take It Back movement. We have a revolution now led by Omoyele Sowore. And all these people, they don't seem to make any impact. What happened really? Why wasn't there that kind of cutover? Why wasn't there more like, how can I put it now, succession plan when you people were elsewhere?
Well, the question of succession planning is always a continuing thing. In my view, anyone who is over 40 in Nigeria, who turns 40 in Nigeria, has to have a plan for replacing themselves, because life expectancy in the country is relatively short. It's in the early 50s, right? But look, Nigeria is what it is. The Nigerian civil society is made up of Nigerians. And the civil society Nigeria has happened to civil society in Nigeria in many ways. What's happened to opposition political parties in many ways has also happened to civil society. APC happened to civil society in one word. You have APC Civil Society Forum, okay? Government infiltrated civil society, just to be brutally honest about it. Politicians infiltrated civil society, bought up people, people know who is whom, and we know who is who. And in that contest, people began to bleed credibility, unfortunately. And ordinary citizens, of course, begin to pick up who is where. And you can see that there were people who were active in articulating themselves when, say, PDP was in power and committing their abuses. And then when APC came into power, they all kept quiet. And after APC has left power, they're now trying to pipe up again. You can't take those people seriously. So this is the summary of what has transpired. I don't think there is anything more exciting than that. And that's why the greater opposition now happens in organized, inarticulate civil society rather than the organized civil society.
Unfortunately, that is what we have. Now, Prof, let's look at the judiciary in Nigeria. Many Nigerians opine that judiciary is a major part of the problems with the Nigerian society in terms of its inability to stabilize the system with pull-through judgments, rulings, and pronouncements. I mean, I can cite many instances. In the immediate aftermath of the 2023 general elections, we saw courts of concurrent and coordinate jurisdictions give conflicting judgments on the same matters in different jurisdictions. Even in the Rivers State Assembly defection of 27 lawmakers, INEC's legal department at a point cried out, they said, look, they were faced with many judgments that they didn't even know which to follow. Does that speak to the level of decline in the judicial delivery of were there clear cases of political manipulation from the executive quarters? If you look at the Labour Party case where the Supreme Court about 10 days ago ruled that, look, the party crisis is an internal affair of the party. Didn't the appeal court judges know all of that? And even at that, the Supreme Court itself went ahead to give a judgment on a matter it said was the internal affairs of a party. Was that some form of contradiction, or was the judgment politically motivated? And do you agree with the Supreme Court judges when they said that, look, that the issue of leadership of a political party, that the courts don't have any jurisdiction about that, over that? What's your quick reaction to that, Prof?
As a matter of principle, I don't comment on judgments I've not read, and I've not read the judgment in the Labour Party Supreme Court decision, so I will not comment on it, on what the court decided or didn't decide.
Okay.
But on the issue of the judiciary generally, of course, the judiciary is in a deep spot of bother. I personally take the view that the problem with governmental legitimacy and crisis of governance in Nigeria is essentially judicially manufactured. And you can see that in Rivers State, for instance, where the Supreme Court decided a case that was not before it. The case that the Supreme Court decided in the case concerning the sequestering of the federal allocation of Rivers State was actually pending at the issue of the consequences of the defection of the 27 legislators in the Rivers State House of Assembly was pending at the Federal High Court. The Supreme Court does not have original jurisdiction over that. It could only take that by way of an appeal. That case was pending at the Federal High Court, had not been decided there, and the Supreme Court decided it without reference to any appeal. That is beyond unprecedented. And the kinds of adjectives I could invent for that are not yet invented in the dictionary. So but I cannot spare the Supreme Court for that kind of thing. And nobody should spare the Supreme Court for that kind of decision making. And it was the Supreme Court that set up, in my view, willfully, the state of emergency, the politically procured state of emergency.
Okay, yes, I was coming to that. Go ahead, sir.
But but this is the way the judiciary has, in many cases, admittedly not all cases, but in many cases, the judiciary has degenerated to beneath a joke. The kinds of things we now see from our courts are not things that anyone can look at and say the judiciary is serious. And that's why the politicians have captured the courts. When you look at the list of judicial appointments, you can actually say this person is from this family. That person is that person's wife. That person is that person's son or daughter. That person is that person's mistress. Okay? And all of these things, the judiciary has become a place for sons, daughters, mistresses, and political wannabes to go and settle their people. And therefore, it is no longer possible to see judgments as reflecting the law and the balance of evidence. It is now a question of whose interest do we want to serve. Okay. And that is what is now dominating our election jurisprudence. Look at the judgment in the Edo State governorship election petition. It's a disgrace. A court should not become counsel for one side of the dispute. What a court should be doing is resolving a dispute between two or more different sides. But in the Edo election petition case, governorship election petition case, the judges were basically counsel for the APC. That's not what judges should be. They should not be articulating for one side or the other. Okay. So this is the standard that the judiciary has been reduced to, or has allowed itself to be reduced to, and it's disgraceful for the most part.
Okay, quite unfortunate. Now, Prof, before we get into the issue around the NBA Annual General Conference, which has generated a lot of controversy, I want to have your perspective on the declaration of the state of emergency in Rivers, which you just talked about a few seconds ago. Now, did the president act in line with the letters and provisions of the Constitution? I spoke to a lawyer, and he said, look, that there's a section of the Constitution which clearly empowers the president to declare a state of emergency in the absence of a total breakdown of law and order. If the president has intelligence that there is a likelihood of a total breakdown of law and order, I mean intelligence provided by the security. Now, other lawyers have disagreed with him. I want to have your perspective on that. Now, consider too that the president went ahead to swear in the sole administrator even before the National Assembly ratified the state of emergency. Was that a constitutional breach? How much of that, how much of that bypass speaks to the fact that the National Assembly is under the thumb of the president, as some Nigerians have alleged? Quickly, before we get into the NBA crisis, the NBA controversy.
I'll ask you a question. How many people were killed in Rivers State before the president declared an emergency?
Okay.
How many people?
Prof, I can't think of any. I'm not sure there's any. I'm not sure there's any.
Thank you. How many people were killed in Uromi?
Okay, 16 people. Yes.
How many people have been killed? How many people have been killed in Plateau?
Uncountable.
How many have been killed in Benue?
Okay, Prof, I get the drift. I get your drift.
Thank you. So I don't want to say too much about this. Rivers State is an abuse of emergency powers.
Okay.
Absolute abuse of emergency powers for quite manifest political purposes. That is not partisan political purposes. That's not what emergency powers under Section 305 of the Constitution were created for. No. Okay? Now, but that's just the beginning, quite apart from the fact that it was a manifestly partisan abuse of emergency powers. The Constitution also requires that, yes, the president may proclaim emergency, but it's got to be, if the National Assembly is in session, the proclamation has got to be ratified by the National Assembly by 2/3 majority of each chamber within 48 hours. If not in session, it's got to be ratified within 10 days. Okay?
Okay.
In the Rivers State case, the National Assembly failed to comply to the extent that the National Assembly ratified the emergency by a voice vote. A voice vote does not enable you to count whether or not you've met the third threshold. Now, and this is where the judiciary has become deracinated, because a judiciary should not, an independent judiciary that is viable should not have difficulties being able to deal with this. The matter is now before the Supreme Court in the case filed by the 11 PDP governors against the federal government as to whether or not as to the legality of the emergency, but also as to the legality of the suspension of democratically elected officers of the state. And so let's see what the Supreme Court is going to do. It's an opportunity for the Supreme Court to either, there is promise and peril in that case for the Supreme Court.
Okay. All right.
That's
Prof.
all I can say.
All right, Prof. Now let's look at the controversy surrounding the 2025 Annual General Conference of the NBA, which you remember, where the sole administrator of Rivers State has demanded a return of the 300 million naira, given to the NBA by the suspended governor Similaya Fubara. Now, the NBA was clear that the money wasn't paid for hosting right. The NBA said it was not contractual, apparently shelving itself from being actionable in that matter. Now, the question is this: if it was not contractual, what form of gift is that? I ask this because some have called it inducement, some have called it graft, some have even called it bribery. Prof, what exactly is it called? And also, I want you to understand that the organizers of the AGC said that they declared 200 million naira to NBA, while the sole administrator said, look, we have recorded that Fubara paid you 300 million naira. How much of that impacts on the integrity of the NBA as an organization?
Well, I'll tell you this story. About 15 years ago, the NBA was doing an election, and a governor of a state in the Middle Belt called his lawyer, who is a senior advocate of Nigeria, still, he was then, and asked the senior advocate of Nigeria, this election that you people are doing, who do you want us to support? Who do you say we should support? And the lawyer said, but Your Excellency, you're not a lawyer. What is your interest in the election of the NBA? To which the governor promptly responded, the NBA is too serious for us to leave to you lawyers alone. Okay?
All right.
I will not say more about that, other than, there's a lot of politicians are interested in what happens in the NBA.
Okay.
Now, in terms of the present issues, all I can say is this: if the governor or this impostor in Port Harcourt, whatever his name is serious about this, look, you don't give that amount of money to people without records. Can he produce the records? It's really that straightforward, so that we can sort this out. A lot of people make donations to the NBA all the time, make payments to the NBA. But if he's saying that he bought contractual rights. You do not buy contractual rights by oral tradition. You buy them with vouchers, receipts, contracts. Can he produce those, please?
Okay. Now, Prof, let's look at we are coasting home. Let's look at your spat with the FCT Minister Nyesom Wike. Now, the altercation started with the attendance of with his attendance, at the Unical 50th convocation ceremony, where Wike attended with a Supreme Court judge, Justice Agim. What exactly was your concern with that sighting of Wike and Agim together? Can they be seen without interpretations being made about their being together? Both of them are lawyers, and what was their concern? Why was it concerning to you that they were sided together? And by the way, you said that at the appropriate time you were going to tell his story. What have you told the story, and how soon do we expect the story if you haven't done that, sir?
No, I've not told his story yet. Okay. But let him push the envelope, and we will tell the story. Look, the fact of the matter is, if you look at the Judicial Code of Conduct, it's very clear that judges, particularly senior judges, should avoid close contact with habitual litigants before them. That's very clear. It's prohibited by the Judicial Code of Conduct. And who are the people who should be setting good example and enforcing the Judicial Code of Conduct? The Supreme Court justices. The week before they showed up in Calabar, Justice Agim was the person who led in that rather curious judgment at the Supreme Court on the sequestering of the arrest of River State's federal allocation. The judgment itself is very, very curious, okay. Or worse than curious. Okay? Now he then shows up sitting cozily beside Mr. Wike, if I may say so. And the week after he showed up in Calabar, Mr. Wike was in Abuja, who was the next judge that he acquired as handbag, the president of the Court of Appeal. It just happens that the president of the Court of Appeal is going to be the person constituting the appeal panel in the Edo governorship election petition, in respect of which Wike's cousin was the electoral commissioner. And you're telling people not to look at all of these facts and draw their own conclusions. Are you that stupid?
Okay, I can see the sweet conjunction of coincidence there. Prof, we are left with 2 minutes. Before we leave, I'd like for you to chime in on the sex advances allegation made against the Senate President by Kogi Central Senator Natasha Agbotu-Uduaghan. Now, recently, according to Senior Advocate of Nigeria, Olisa Agbakoba, Natasha's allegation is watery. What's your reaction? And let's have your concluding thought on the state of the nation. 2 minutes, if you can, sir.
Olisa was my boss. And so, and Natasha is my friend. Okay. And Godswill Akpabio was my classmate in the Nigerian law school. He sat 2 seats in front of me in the Nigerian law school.
Okay.
Unfortunately, I think we've got to be fair to the facts. If these people, if Olisa and Akpabio are looking for a fair circumstance to handle this situation, what they need to do is recall Natasha to the Senate. Let's start from there.
Okay. All right then.
They can't exclude her in these circumstances and be talking about how this is about sexual harassment, is about Olisa's daughters. That's just nonsense. I'm sorry.
All right. Now, this is where we wrap up the show. Big thanks to you, Professor Chidi Anselm Odinkalu, lawyer, human rights activist, professor, and a writer. I appreciate it.
Do you want your voice to be heard? Do you know that you matter in the scheme of things? The People's Voice, the show where ordinary citizens take center stage as we discuss the biggest stories that affect you and I. With you in mind, we facilitate lively discussions, debates, and interviews on the topics that matter most to you and I, from social justice to economic empowerment, education to healthcare, governance, and more. Tackling tough topics and amplifying your voice. People's Voice, Mondays through Thursdays, 7 p.m. to 8 p.m. Join the conversation and make your voice count. The People's Voice. Make your voice count.
Commissioning the commercial operation. We are not commissioning beauty. access road. So how will you use it? If I stay in Itu, how do I have access to the station when there's no road to the station? If I stay in Kukuba, how do I have access to it when there's no road? So all those non-availability of access roads impeded the operation of the metro line. You remember in September last year, when the president was declaring open the annual bar conference of the Nigerian Bar Association, the president said, the chief host, I want to ride on the metro line. I don't want land. I want to ride on the metro line. To the glory of God, on Monday, 27, Mr. President will ride on that metro line. So all the access roads have been done. In fact, the last administration awarded $128 million for 29 months for the CCECC to train our people for the operation of that metro line. 100. It's not for Mr. President, it's for you.